Aslamo.alaikum. Welcome back to our channel, True Courtroom Stories. Kindly subscribe our channel, like and share with friends, and serve. This is the episode 108 of True Courtroom Stories, researched by Mr. Zahir Ahmad Mir. Okay, let's unpack this. Setting aside that necessary framing, we have been given just an incredible set of sources today, and they all focus on a single core legal concept, the right to counsel. This deep dive is going to take us across, well, vast stretches of human history and multiple legal systems.
It really is.
All to understand why defense is not simply a courtesy, not just a privilege, but a really non-negotiable pillar of justice.
That's the perfect way to put it. What we have here is a comprehensive set of materials that let us trace this single, unbroken principle.
Unbroken is a great word for it.
It is. It goes from ancient legal practice, really ancient, right up through modern constitutional doctrine.
So what's our mission today? What are we trying to synthesize from all this?
Well, our task today is to conduct a really comprehensive synthesis of this rich material. We're dealing with 4 critical interlocking perspectives. Okay. First, we have a historical precedent, and this one is found in the Islamic legal system of the Abbasid Caliphate. It's a remarkable testament to early institutional justice.
That's already fascinating.
Then second, we jump forward to a crucial global landmark in the form of the 20th century U.S. Supreme Court case, Gideon v. Wainwright.
A case a lot of our listeners will have heard of, I'm sure.
I would think so. Third, we have a contemporary national doctrine, and this is represented by Pakistan's modern fair trial principles.
So we're bringing it right up to the present day.
Exactly. And finally, and this is the glue, we have the essential philosophical ratio that ties every single one of these, seemingly disparate legal achievements together.
So it's not just about listing them.
No. Our mission today is robust. It's not just to summarize these points, but to conduct an intense analysis of the singular, powerful argument they collectively make about the non-negotiability of the right to defense.
We're looking for the common thread.
The common DNA, you could say. The legal and ethical imperative that links a medieval caliphate court, which was founded on religious law, to a 20th century American courtroom applying constitutional protections. It's a huge leap.
It is a huge leap. And that common DNA, that core hook, the defining principle that's going to act as our intellectual compass for this entire deep dive, is captured in 4 succinct, powerful words that are right there in the source material.
And they are powerful.
Justice without defense is oppression.
And here's where it gets really interesting for me. We are charting the journey of that conviction across civilizations. We're asking why this principle had to be, discovered and then maybe lost and then rediscovered time and again.
It's a cycle.
It's a fascinating cycle.
Yeah.
So let's start right there with the foundation, because that ratio is incredibly potent. Justice without defense is oppression.
I want to really chew on that word. Oppression. Why that word? Why is the lack of defense inherently characterized as oppression? Why isn't it simply called, unfair or maybe just inefficient? That word implies a systemic abuse, a wielding of power by the strong against the vulnerable.
It does, and that's precisely the point. It forces us to move the discussion far beyond mere procedural inconvenience or, a technical error.
Right. This isn't just about paperwork getting lost.
Not at all.
Yeah.
When our sources use the word oppression, they are referencing the profound structural asymmetry that's just inherent in any state prosecution. Oppression, in this legal context, is the act of the state, which is the repository of all institutional, financial, and evidentiary power. Everything, wielding that immense strength against an individual who is, for all intents and purposes, fundamentally disarmed.
Can you break that down a bit? What does that imbalance actually look like in a courtroom?
Well, to really understand the weight of this, just consider the sheer scope of the imbalance. The state possesses trained police and investigative bodies. They have a dedicated public treasury, a budget, to fund their actions. They retain highly trained prosecutors. They command access to state-of-the-art forensic science and expert witnesses. And, of course, they wield the ultimate power of incarceration. All of this is mobilized against a single person.
And that single person, the accused, is often scared, maybe uneducated, and is almost certainly untrained in the law.
Exactly. When you remove that professional defense counsel, you're essentially asking an untrained, often financially destitute, and deeply stressed layperson to somehow navigate a Byzantine, complex, ritualized legal framework.
A framework they've never seen before.
Against this juggernaut of institutional power. The resulting process, It cannot logically or morally be called justice because the core mechanism for truth discovery, which is rigorous adversarial challenge, is completely absent.
So without that challenge, it's not a real inquiry.
It ceases to be a fair contest, and it becomes really an administrative formality. The state presents its evidence, and since there is no skilled counter voice to test the admissibility, the credibility, or the relevance of that evidence, well, the conclusion often seems preordained.
It's a performance.
That's a good way to put it. That is the definition of procedural oppression. The system is so heavily weighted that the outcome is practically guaranteed regardless of the actual facts.
That structural imbalance is the true systemic threat.
Yeah.
I mean, if the purpose of the justice system is to find the truth, it must allow every piece of evidence, every witness statement, and every legal theory presented by the state to be tested to its absolute breaking point.
It has to.
But for the individual accused to do that themselves, it's functionally and practically impossible. It's not just a matter of intelligence, it's a matter of highly technical skill.
The analogy you used earlier about the novice swimmer and the speedboat is very apt. I mean, even an Olympic-level swimmer would struggle to pilot a speedboat they had never operated before. The legal system is a technical machine, and defense counsel are the mechanics trained to operate, scrutinize, and, if necessary, dismantle that machine.
Okay, so let's get specific. We need to move past the simple idea that defense counsel just argues for innocence. What specific functions does the defense truly provide that uphold the structural integrity of the entire system, proving they are a necessity for justice itself?
That's the key question. Defense counsel fulfills several indispensable functions that ensure the process is legitimate. The first, and maybe the most fundamental, is ensuring due process.
And what does that mean in this context?
Due process is simply the state following its own rules. This means the defense has to ensure the police followed protocol in obtaining evidence, that arrests were legal, that questioning was conducted within the bounds of the law, that search warrants were properly executed.
All the procedural stuff.
All the procedural stuff that guarantees fairness. Because a legal system that ignores its own rules is capricious and arbitrary, which is, again, a form of systemic oppression.
So, in a way, the defense is the auditor of state power.
Precisely. That's a perfect description. The second critical function is the rigorous testing of evidence. Prosecutors present a narrative and the evidence to support it.
Right, they tell a story.
They tell a story. Defense attorneys challenge the reliability of that evidence. Was the testimony hearsay? Was the DNA processed correctly? Were chain of custody rules for a piece of evidence followed? They challenge the credibility of witnesses. Do they have a bias? Do they have a motive to lie?
Without someone asking those questions.
Without that rigorous testing mechanism, flimsy, circumstantial, or even illegally obtained evidence might stand unchallenged, leading directly to wrongful convictions.
Okay, and is there a third function?
There is, and it's one that's often overlooked. It's mitigation and sentencing. So, even if the accused is factually guilty, defense counsel ensures that the law is applied correctly, that mitigating factors are heard, and that the sentence is proportional and fair.
Ah, so it's not just about the verdict.
Not at all. Oppression can occur not just in the trial, but in the punishment stage if the system ignores the individual humanity of the defendant. The defense is there to ensure that humanity is seen.
That is the true essence of the adversarial system, isn't it? It is a necessary refinement mechanism designed not just to convict the guilty, but to protect the integrity of the truth-finding mission.
Exactly.
It ensures that if a verdict is reached, it is only after the most robust challenge possible has occurred. So if we visualize that scale again, on one side you have the state's virtually limitless resources.
The police, the state attorneys.
The comprehensive archives of evidence, decades of precedent. The defense has to be the structured, skilled, professional counterweight required to bring that scale back into equilibrium.
It has to be.
If you remove the defense, the scale tips instantly and dramatically, and what you get is procedural tyranny, which the source material rightly defines as oppression.
That phrase, procedural tyranny, captures it perfectly. And if we accept this fundamental ratio, this core principle, then every successful mechanism that establishes a skilled defense, regardless of the century or the legal tradition, is simply an institutional response to that challenge.
The challenge of preventing state power from becoming tyranny.
Correct. The Abbasids, the U.S. Supreme Court in Gideon, and Pakistan's modern doctrine, they were all fundamentally trying to solve the exact same problem. How to prevent the state's legitimate power from becoming oppressive power against the individual.
So this raises an important question for us then.
It does. If the necessity of defense is this profound transcending time and culture, then we have to look at the specific, detailed institutional responses that different societies created to meet this ethical mandate.
Right. How do they actually do it?
How do they pay for it? Who are the professionals? And that brings us, chronologically, to our first and maybe most surprising historical example.
Okay, let's go there. We jump back over 1,000 years to the Abbasid Caliphate, which was roughly from the 8th to the 13th centuries, centered in Baghdad. Our sources point directly to the existence of institutionalized, court-appointed defense in this era. This is not anecdotal evidence of a kind judge here or there. This implies a formal structure.
It does, and the existence of court-appointed defense in this high point of Islamic civilization is a profound historical marker.
Yeah.
It instantly dismantles the common misconception that state-funded legal aid is a modern 20th century invention of Western democracy.
I think most people assume that.
I think so too. But this shows that the concept of the state guaranteeing professional legal representation is a deep-seated ethical necessity in jurisprudence that goes way, way back.
So, to have a system of court-appointed defense, that means the state recognized an obligation. How did this actually function in practice within the Abbasid court system? We should probably define some of the key players here, as the terminology can be confusing.
Absolutely. The key figure in the Abbasid legal system was the Qadi. The Qadi served as the judge.
The judge, okay.
And he was both the adjudicator of fact and law, and often held administrative responsibilities as well. The legal professionals who represented litigants were often called wakil.
Wakil?
Yes, which translates essentially as an advocate or attorney, or sometimes just a representative.
And what was the Qadi's role in all this?
The Qadi's role was complex. He was tasked by the Caliph to uphold justice, the Arabic term is adla, and to prevent wrongdoing or injustice, which is zulm.
Adl and zulm.
Right. So if the Qadi observed a defendant who was indigent, meaning unable to pay for representation, or who's clearly incapable of presenting his own defense due to illiteracy, ignorance of the law, or just the complexity of the charges, the ethical duty of the Qadi required intervention.
So the mechanism of appointment arose from the judge's own ethical obligation to ensure justice.
That's the root of it.
But how did they institutionalize that, especially the compensation? I mean, if the defendant couldn't pay, someone had to. You can't just expect lawyers to work for free all the time.
And this is where the sophistication of the Abbasid state structure comes into play. If the Qadi determined that an accused needed a wakil, but could not afford one, the compensation for that advocate would typically be drawn from the state treasury.
The state treasury.
Which was known as the Beit al-Mal. And this mechanism is critical to understand.
Why is that so significant?
Because the fact that the Beit al-Mal was used implies that the defense of the indigent was viewed as a public good. It was seen as a legitimate state expenditure, something necessary for the maintenance of judicial legitimacy.
It's an investment in the system itself.
It reinforces our core ratio perfectly. The cost of preventing oppression, which is the result of an unfair trial, was borne by the society as a whole through the state.
That is a direct practical response to the power imbalance we were talking about. By using state funds to hire a skilled wakil, they were ensuring professional parity. The state was actively balancing the scales it had inadvertently tilted through its own institutional power.
And this required a professional class. It's important to note, the advocates, the wakil, were often drawn from the ranks of respected jurists, the fuqaha, or sometimes the learned scholars, the ulama.
So these weren't just random people?
No, not at all. These were people who possessed deep knowledge of Islamic law, Sharia, and legal methodology. To be a court-appointed wakil meant you were providing a specific, high-level technical skill.
So the system wasn't just about charity or pity. It was a recognition that justice requires competence.
Yes.
Simply allowing a poor man to walk into a complex court environment against a state prosecutor or a skilled private adversary, even if the court was inherently fair, would lead to an oppressive outcome because he couldn't speak the legal language.
Exactly. This historical precedent forces us to challenge the idea that justice is achieved merely by opening the courtroom doors.
It's more than just access.
Much more. It showed that access to the court must be supplemented by access to competence. Furthermore, it showed that the system was mature enough to understand that innocence alone is not a sufficient defense. You need the procedural knowledge to demonstrate that innocence within the rules of the system.
That understanding of procedural necessity 1,000 years ago is deeply compelling. It demonstrates that the problem, the state's power overwhelming the individual, is universal and timeless.
And if we connect this to the bigger picture, the Abbasid system demonstrates the ethical driver we mentioned. The pursuit of justice was considered a divine and societal duty, and it overrode financial capability.
It had to.
It had to. If the court is a cornerstone of societal order, its fairness cannot be compromised by the economic status of the accused. If it didn't provide a competent defense, the entire legal system would risk being categorized by the very oppression, the zulm it was designed to prevent.
Let me push back on this a little bit. Let's consider a point of potential vulnerability. If the appointment of the wakil relied heavily on the qadi's discretion, him deciding who was indigent or whose case was complex enough, wasn't that system still vulnerable to the bias of the judge? Couldn't that undermine the anti-oppression principle?
That is a probing and a very necessary question. No human system is perfect, and discretion always carries risk.
Of course.
However, the Abbasid legal tradition operated within a rigorous framework of accountability. There was accountability to the caliph, but maybe more importantly, to the established legal schools of thought, the madahib.
So there were checks and balances.
There were. A qadi who systematically denied defense to the poor would be violating clear ethical and jurisprudential mandates of the Sharia, and that could potentially lead to his removal or his decisions being overridden by a higher judicial authority. The system tried to mitigate bias by anchoring the discretion within a mandated ethical duty.
So it wasn't just up to one person's whim.
Not entirely. So while the structure relied on the integrity of the qadi, the foundational principle was clear. When the state acts to deprive a person of liberty or property, it must ensure a fair contest. The Abbasid system provides compelling evidence that the commitment to defense counsel is a deep-seated jurisprudential necessity that emerged long before modern constitutionalism.
Okay, so from that ancient ethical mandate, we're going to transition now to the modern constitutional world and the global mandate set by the 1963 U.S. Supreme Court case, Gideon v. Wainwright.
A huge shift.
It is. And our source identifies this case as a global standard. We need to understand exactly why a U.S. domestic case, one interpreting the 14th Amendment, resonated so strongly across continents.
The significance of Gideon v. Wainwright lies in its revolutionary clarity. It was a judicial turning point that formalized the ethical duty we saw in the Abbasid system into a rigid, non-negotiable constitutional right.
So it took it from an ought to a must.
Precisely. And to fully appreciate the shift, we have to first understand the oppressive system that Gideon overturned.
What was the law before 1963?
Well, prior to 1963, in many U.S. state felony cases, the right to counsel for indigent defendants was governed by something called the Special Circumstances Rule. This was established by a 1942 case called Betts v. Brady.
Special circumstances, what does that mean?
It meant that the state only had to appoint counsel if the trial presented special circumstances. For instance, if the defendant was illiterate or mentally incompetent, or if the charges were exceptionally complex, or if it was a capital offense.
So under that system, the decision of whether a defendant received a lawyer was discretionary. It depended on the subjective assessment of the judge about the case's complexity or the accused's competence.
Exactly. And this discretionary system was functionally oppressive. It was oppressive because it placed an impossible burden on the unrepresented defendant to prove that they couldn't defend themselves, often after the trial was already lost.
You had to prove you were incompetent to get help. It's a catch-22.
It's a total catch-22. It led to arbitrary outcomes, where justice depended on the defendant's ability to articulate their own incompetence, or, frankly, the judge's mood that day. It created a two-tiered system of justice, one for the rich who could hire skilled representation, and one for the poor who had to beg for it.
And that takes us right back to our core ratio. Justice without defense is oppression. The discretionary system was the institutional mechanism for that oppression. So tell us about Clarence Earl Gideon. How did his personal fight change the global legal landscape?
Clarence Gideon was, by all accounts, an ordinary man. He was accused of breaking and entering a pool hall in Florida, which was a felony. At his trial, being indigent, he asked the court to appoint him a lawyer citing the U.S. Constitution.
And what happened?
The court refused. They cited the established Florida rule that counsel was only provided in capital cases. So Gideon was forced to represent himself. He was convicted, and he was sentenced to 5 years in prison.
But he didn't give up there.
No. From prison, he filed a handwritten petition, a writ of certiorari, to the U.S. Supreme Court. His argument was simple but powerful. He argued that the state's refusal to appoint him a lawyer violated his constitutional rights.
And the Supreme Court agreed to hear it.
They did. And when they took the case, they recognized that the system itself was flawed. They unanimously ruled that the special circumstances rule was unworkable and fundamentally unjust.
So what was the new rule?
By declaring that lawyers are necessities, not luxuries, the Supreme Court essentially acknowledged that the system is inherently oppressive if it proceeds against an indigent defendant without a trained advocate. It made the right to counsel per se.
Meaning?
Meaning it is required in all felony cases automatically, regardless of the defendant's perceived intelligence or the complexity of the facts. No more discretion.
It was a declaration, then, that for any criminal trial concerning potential liberty deprivation to be considered legitimate, counsel must be present.
It was. The court recognized that the complexity of modern law necessitates professional guidance. Without it, you are denying a fundamental condition of liberty. Justice Hugo Black, in his famous opinion, wrote that lawyers in criminal courts are necessities, not luxuries.
A very powerful line. Now, let's address the global reference in our source material. Why does a decision specific to Florida law and the U.S. Constitution become this global standard?
The global influence stems from the powerful moral and legal clarity of the principle it established. Gideon affirmed a universally transferable idea that the state has an affirmative constitutional obligation to ensure that poverty does not become an automatic ticket to conviction.
And that idea just resonated.
It resonated across the globe, particularly in the mid to late 20th century. This was a period when many nations were drafting or revising their own constitutions, often following decolonization or major political transitions.
They were looking for models.
They were looking for models. Many post-colonial states seeking to establish democratic legitimacy and move away from arbitrary colonial legal systems, they actively studied U.S. and European constitutional precedents. Gideon provided the clearest, most robust legal template for what a truly fair justice system must provide.
So it wasn't about copying the U.S. system wholesale?
No, it was about adopting the principle. It affirmed that legal competence cannot be a luxury and that the system's legitimacy rests on providing a defense for the poor. It elevated the right to counsel to the level of a basic human right necessary for true liberty.
So when a new nation codifies the right to legal aid or mandatory defense for the indigent, they are often mirroring the ethical imperative we saw in the Abbasid era, but formalizing it through the actionable legal standards set by Gideon.
Precisely. Gideon is cited globally, not for its procedural specifics on U.S. due process, but for its powerful affirmation of the moral obligation. It became a measure of a mature justice system. A nation might have prisons and courts, but if it systematically denies professional counsel to the poor in serious cases, its claims to justice are undermined.
It's a baseline for legitimacy.
It is. Gideon provided the legal and philosophical ammunition necessary to challenge those unfair systems everywhere.
It feels like the ultimate bridge, then, between that ancient ethical mandate, where the duty lay upon the judge or the caliph to ensure fairness, and the modern constitutional state, where that duty is codified as an enforceable institutional requirement imposed on the legislature and the courts.
It is the perfect bridge.
And this transition shows that the principle isn't static. It's constantly being reaffirmed to meet the complexities of ever-evolving legal systems.
It has to evolve.
So, having charted this journey from the ethical imperative of the Abbasids and the constitutional mandate of Gideon, we now need to ground this universal concept in a specific modern legal framework. Pakistan's fair trial doctrine.
Right.
This is where abstract rights meet detailed, day-to-day legal enforcement.
This final step is absolutely essential because it demonstrates the practical, active translation of that core ratio into modern state responsibility. The fair trial doctrine, particularly in Pakistan, is not just some vague aspiration.
It's written down.
It's codified as an enforceable constitutional right, enshrined, for example, under Article 10A of the Constitution. And that article explicitly mandates that for the determination of civil rights and obligations or in any criminal charge, a person shall be entitled to a fair trial and due process.
So the doctrine acts as a comprehensive quality assurance framework for justice. It's an active mechanism designed to prevent the state's power from becoming oppression, just as the Abbasid system aimed to do.
A direct lineage.
So how does the right to counsel fit specifically into this doctrine, and what practical protections does it mandate?
Well, the doctrine recognizes that a fair trial is completely impossible without competent legal representation. It's the linchpin. Therefore, it mandates the inclusion of defense counsel as a non-negotiable component. And the doctrine encompasses several interlocking rights, all of which are rendered pretty much meaningless without a lawyer.
Like what? What are some of those rights?
Well, for instance, the doctrine requires the right to adequate preparation. In modern law, that means having access to all the evidence documents, and witness statements the state intends to use against you.
The process known as discovery.
Exactly. A layperson would know what to ask for, or how to interpret complex documents, or how to challenge their admissibility. Counsel is indispensable here. It ensures the accused is not fighting blind.
That is a critical expansion. So it's not just about showing up with a lawyer on the day of the trial. It's about the lawyer having the resources and the legal right to access the state's information, ensuring a level playing field before the trial even begins.
Absolutely. The doctrine also focuses heavily on the right to present evidence and, most crucially, the right to cross-examine and confront witnesses.
Which is what you see in the movies.
Right. But it's not just for drama. Presenting evidence effectively means knowing the rules of evidence, when something is admissible, how to lay the proper foundation for testimony, how to counter objections from the prosecution. And cross-examination is the most skilled element of trial advocacy. It is the act of testing the truthfulness and consistency of the state's narrative.
And without a lawyer?
Without a trained defense counsel, the accused cannot effectively challenge the state's witnesses or introduce counter-evidence according to those strict rules. The process is compromised, and the resulting verdict is, by the definition of our core ratio, rooted in procedural oppression.
Okay, we have to ask the practical question again. How does the Pakistani legal system ensure that indigent defendants actually receive this mandated counsel? Does the doctrine specify state funding or a legal aid structure?
Yes, the system has evolved to ensure practical implementation. While the mechanisms can vary across different provinces and courts, the fair trial doctrine compels the state to establish legal aid mechanisms.
So there's a structure in place.
There is. For example, in cases involving serious offenses, especially those potentially leading to life imprisonment or the death penalty, the appointment of state-funded defense counsel is mandatory and constitutional. It mirrors the strictest applications of the Gideon principle.
And does it go beyond just appointing someone?
It does. The Supreme Court of Pakistan and various high courts have continuously interpreted the fundamental rights provisions to impose an active burden on the police and prosecution to ensure fairness from the very initial investigation stage onward.
So from the moment of arrest?
Yes. This goes beyond merely assigning a lawyer to defining what an effect assignment entails. It holds the state accountable for the quality of the justice provided.
That distinction, the move from merely assigning a lawyer to ensuring the assignment is effective, that feels like the critical modern evolution of this right.
It really is.
It demonstrates a maturity in the legal system, acknowledging that a rushed, poorly prepared, or incompetent defense is functionally the same as no defense at all, and thus still leads to oppression.
That is the modern battleground. The existence of a robust fair trial doctrine demonstrates how modern states translate those abstract historical and judicial precedents, the Abbasid appointed defense and the Gideon global mandate, into practical, day-to-day legal reality. It is the comprehensive, systematic response to the demand for accessible justice.
A response built on the recognition that the state cannot prosecute fairly unless it also ensures the accused is legally equipped to fight back. So we've completed the map of this universal journey. We have a foundational philosophical principle. Justice without defense is oppression, which is clearly articulated. It manifested institutionally in the court-appointed wakil system of the Abbasid era. It was then formalized globally in the 20th century through Gideon, making competence a constitutional right. And finally, it's integrated into a comprehensive, modern national structure like Pakistan's fair trial doctrine, ensuring enforceability across all stages of the legal process.
It creates an incredibly powerful argument for the universality of this right. It shows that irrespective of the religious or political framework, medieval or modern, East or West, the core flaw of a justice system that permits state power to proceed unchallenged against an unrepresented citizen remains the same.
And the solution remains the same.
The solution, across millennia, remains skilled, state-insured defense. It is a necessary countermeasure to the state's legitimate but overwhelming authority.
It makes you appreciate that all major legal traditions of the world, despite their differences, are grappling with the same fundamental human problem.
They are.
How to balance the need for social order and security with the absolute protection of individual liberty. And every time, the answer keeps coming back to the necessity of professional counsel.
That is the essential insight. The principle of the right to counsel is not some historical artifact or a regional anomaly. It is a fundamental, essential requirement of any legitimate authority. When a state acts to punish, It must also act to guarantee the fairness of that process. And the greatest structural guarantor of fairness is the right to a robust defense.
So what does this all mean for you, the listener? We started this deep dive with that powerful ratio from our sources. Justice without defense is oppression.
A powerful starting point.
It was. We saw this principle articulated in the institutionalized, state-funded, court-appointed defense of the Abbasid era, confirming its ancient ethical roots in jurisprudential duty. We then watched it get formalized and expanded as a mandatory global constitutional standard through the pivotal decision in Gideon v. Wainwright.
Ensuring that poverty could not nullify fundamental rights.
Exactly. And finally, we saw it enshrined and made actionable in modern legislative and constitutional systems like Pakistan's fair trial doctrine, which translates that high-minded philosophy into daily legal reality.
The synthesis is remarkably consistent when you lay it all out like that. The right to counsel is a single, uninterrupted, universal thread woven through human legal history. It is the ultimate safeguard.
And it's not just a technicality.
It's far more. It's not just about protecting the accused. It's about protecting the legitimacy of the judicial process itself. If the process, regardless of the eventual outcome, is guaranteed to be fair, tested by competent defense, and conducted in the open, then the verdict stands on solid, equitable ground.
And it resists that categorization of oppression.
Precisely.
This means that every time a country, a court, or a legal doctrine mandates defense counsel, especially for the indigent, they are directly adhering to this millennia-old mandate to counterbalance the state's power. They are actively choosing justice over institutional oppression, and that's a choice that has defined legal maturity across epochs.
But the challenge for modern societies has subtly shifted. It's no longer just about whether a lawyer is provided. Our sources show that many jurisdictions have, in principle, solved that problem. The critical focus now is on the quality and the parity of that provision.
Right. And if the fundamental right to counsel is universal, as these sources so strongly suggest through their diverse examples, we are left with this crucial, provocative question for you to mull over.
It's a big one.
It is. In a world of increasing legal complexity where evidence involves cutting-edge forensics, digital data, and incredibly specialized statutes, what continuous institutional effort must societies make to ensure that the quality of that defense, the competence, the training, and the resources provided to the indigent never falls short of the ideal required for true substantive justice?
How do we keep the promise?
How do we keep the promise and fully honor that ancient conviction that justice without defense is ultimately oppression? Because the commitment to the right to counsel seems to be a constant, ongoing negotiation with the potential for tyranny.